Christopher Ernest Holt.
On the record.
Okay, this is case number 22 CR 243, State of Ohio versus Christopher Ernest Holt. Mr. Holt's appearing on video by Zoom from on the screen that is marked C. Sloan. This hearing is being conducted by Zoom. His attorney is William Armentrout, appearing from his office. Appearing on behalf of the state is Assistant Prosecutor Adam King. Defendant has entered a plea of guilty to aggravated possession of methamphetamine in violation of section 292511, a fifth-degree felony. Mr. Armentrout, you and your client both in agreement that this sentencing can be conducted remotely by Zoom rather than his in-person appearance.
Yes, Your Honor.
All right, and you're all right with that, Mr. Holt?
Yes, sir.
All right. And Mr. Pilley, I see you on the screen there. We'll be ready for Mr. Weil as soon as we get done with Mr. Holt.
Yes, sir.
Okay, thank you. All right, Mr. King, anything on behalf of the state?
Only was contained in the plea agreement, Your Honor.
All right, Mr. Armentrout?
Your Honor, I had a chance to speak with Chris yesterday. He's doing extremely well where he's currently at, and he hopes to complete that and continue into sober living. So we'd ask the court to follow the agreement and place him on community control.
All right. Mr. Holt, anything that you would like to say?
No, sir. I am doing really well down here. I think my only regret is I didn't find out about this place sooner. Really good program.
And I see that according to my the notice from Ms. Sturgill that you did not wish to apply to be admitted into the drug court. Is that correct?
Yes, sir.
All right. Well, I think that's a mistake given your history, but it's your choice. The court doesn't order people into that program. But I'll also say that given that, that means that you're going to be on a little bit tighter leash because, quite honestly, you've had a history, several convictions. Looking here, let's see, you've had 1, 2, 3 felonies, it looks like, and have been to prison at least twice, I guess. And so generally, people with your kind of a record need more intense supervision, but it's your choice. So I'm going to give you the opportunity to prove that you're serious about your recovery, although, again, people usually that don't want to be in drug court are usually just trying to stay out of prison, and their success rate is about a third lower than those people that are in drug court, at least in the last 4 years. But in any event, it's the order of the court that you be and are hereby sentenced to a term of 3 years of community control under the supervision of the probation department under these conditions. You obey all laws of all jurisdictions, conduct yourself in a law-abiding manner at all times, must report when and as directed, must be truthful in all statements you make to the probation department regarding your community control. You must keep them informed of your residence, place, and employment at all times. May not change either without prior permission. May not leave the state of Ohio without prior written permission. May not enter upon the grounds of any correctional facility, nor may you communicate with or attempt to communicate with anyone as an inmate in any of those facilities without prior written permission. Because of your convictions, you're prohibited under both federal and state law from possessing, owning, using, purchasing, or having under your control any firearm, ammunition, or dangerous ordnance of any type. And it is a felony under both federal and state law to do that. It's also a condition that you not have any of those or any other types of weapons while under community control. You may not purchase, possess, use, or have under your control any kind of a controlled substance, drug of abuse, CBD, oil, kratom, or any variant or analog of any controlled substance that has effect similar to a controlled substance or a drug of abuse, nor any instrument, device, or thing that may be used to administer those or prepare them for administration, unless you have a lawful prescription, a copy of which you must provide your supervising officer within 24 hours of receipt. You submit to drug testing when and as requested by the probation department or your treatment provider. You're not to purchase, possess, use, or have under your control any alcoholic beverage or be present in places where they're sold or being consumed if even otherwise lawful. Not to associate with anyone as a co-defendant in this case, nor any other person as a criminal record, member of a gang or any criminal group, or any other person as a past or could in the future influence you to commit a criminal offense or to violate these conditions, unless that's approved in writing by your supervising officer. That applies to any family members that fall within that definition unless you were living with them immediately before the commission of this offense. After the date of this order, you may not marry or establish cohabitation or common law marriage type relationship with another person without written permission. You must report any conviction, arrest, citation, or other charge of violating the law not later than the next business day after that occurs. You must provide your supervising officer with financial information records so your ability to pay any fees or costs can be reviewed. If you're referred by probation for any further evaluation or assessment for any other type of programming, you're to submit to that. If any programming is recommended, you're to enroll in and successfully complete that. You will pay the court costs of this action, make payment arrangements to do that with the clerk. You're to perform 400 hours community service rated 20 hours per week for 20 consecutive weeks unless you're employed at least 20 hours a week, a full-time student, or you have documentation by a physician or a prior disability finding you're unable to do that. You're to successfully complete the TCC residential programming and any aftercare that's recommended. Now, by being placed on community control, you're deemed to have consented to a search without a warrant of your person, your residence, your vehicles, or any other property place that's under your control where you're found at any time by any officer of the probation department. Now, you're also ordered to pay the cost as a substantive order. If you don't make payment arrangements and do not make payments, then the clerk can collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then the court could order you to do additional community service above and beyond that already ordered, and give you credit for each hour you work in an hourly rate set by the court each hour you work, or reduce your judgment by that amount until paid in full. Now, in the event that the probation department feels that you have failed to comply with these conditions, they'll file a written notice of that with the court. There'll be a hearing set. You'll be entitled to have an attorney. If the outcome of that hearing is that you have failed to comply, then at that time the court can revoke your community control and sentence you to a prison term between 6 and 12 months and fine you $2,500. Now, if that occurs, once you complete your prison term, the law provides that as part of the sentence, the adult parole authority could, their option, put you under post-release control supervision for a period of up to 2 years. If they do, you'll be supervised on the terms they set. And if during that time they determine that you have failed to comply, then the court, as I said, will have a hearing and appoint an attorney for you if you wish one. And if the outcome of that is you fail to comply, well, wait a minute, I'm doing too many things here. I'll back up. A post-release control. If the APA determines that you have failed to comply, then they can return you to prison and make you serve an additional period of up to 9 months, or in this case, half of your prison term for one or more violations. But if you committed a felony, then in addition to whatever sentence the judge in the new case can impose upon you, the judge could also sentence you for committing that offense under post-release control, in this case, to an additional period of a year, whatever time left on that period of post-release control, whichever is greater. And if that occurs, that's served consecutively to the sentence in the new case. All right. Now, is there anything further from counsel?
No, Your Honor.
All right, you're related, or you'll be there, and the probation department will be in touch with you.
Okay.
All right. Let's see, Stephen
Your Honor.
Charles Weil. All right, this is case number 22 CR 129, State of Ohio versus Charles Weil. And you're Charles Weil, appearing on the screen there, marked Adam Hilly.
Yes, sir.
All right. This is a sentencing hearing being conducted by Zoom. Mr. Weil's attorney is William Armentrout, appearing from his office, also appearing on behalf of the state is Assistant Prosecuting Attorney Adam King. Mr. Armentrout, you and your client both agreed to this sentencing being conducted remotely by Zoom rather than an in-person appearance?
Yes, Your Honor.
All right. Now, the defendant has been convicted of a plea of a crime of aggravated possession of methamphetamine under 2925.11, a third-degree felony. The court ordered pre-sentence investigation, and I've received that. And have each of the attorneys received a summary?
He has.
I have not, Your Honor.
All right. Mr. King, anything on behalf of the state?
Only what is contained in the plea agreement, Your Honor.
Mr. Armentrout?
Your Honor, we'd ask the court to file the plea agreement. I believe that he does want to be accepted into the drug court. He's already in rehab, as the court can tell. He's sober now, doing well, and he would like to continue with that.
All right, Mr. Weil, anything you'd like to say?
Just I'm at the Massey house, doing good, just trying to complete it, and I'm looking forward to starting the drug court. I think you guys got good resources that'll help me out and stay clean and out of jail.
All right. Well, then the court finds that the defendant does meet the qualifications for admission in the drug court and has indicated his desire to be placed in that docket. So it's the order of the court the defendants be admitted into the drug court docket for substance abuse treatment, and you're sentenced to a term of 3 years of community control under the drug court docket as follows. First of all, you'll be required to comply with all of the requirements set forth in the drug court docket program description and attachments, which you've been provided and was set forth in your acknowledgement, was filed with the court. You're familiar with those, right?
Yes, sir.
All right. I'm going to highlight some of them, not all of them. First of all, you obey all laws of all jurisdictions, conduct yourself in law, body, and manner at all times, report when and as directed, be truthful in all statements you make in the probation department, keep your supervising officer informed of your residence, place, and employment at all times, may not change either without prior permission, may not leave the state of Ohio without prior written permission, may not enter upon the grounds of any correctional facility, nor may you communicate or attempt to communicate with anyone as an inmate in any of those facilities without prior written permission. You may not purchase, possess, own, or use, or have under your control any kind of a firearm, ammunition, dangerous ordnance, or weapon of any other type. And it's a violation of both federal and state law, a felony. If you do any of those things, it's also a prohibition, a condition of your community control. You may not have any other weapons of any other type. You're not permitted to purchase, possess, use, or have under your control any controlled substance, drug of abuse, CBD, oil, kratom, or any variant or analog of any controlled substance, drug of abuse that has effects similar to those, or any device thing may be used to administer or prepare that administration unless you have a lawful prescription, a copy of which must be provided to your supervising officer within 24 hours of receipt. You may not obtain a medical marijuana card while in the drug court docket, and you're to submit to drug testing when and as requested. You are not to purchase, possess, own, use, or have under your control any alcoholic beverage, nor be present in any places where they're sold or being consumed, even if that's otherwise lawful. You're not to associate with anyone who's a co-defendant in this case, nor with any other person who has a criminal record, member of a gang, criminal group, or any other person who has in the past or could in the future influence you to commit a violation of these conditions unless that's approved in writing by your supervising officer. You may not, after the date of this order, marry or establish cohabitation, a common law marriage type relationship with another without written permission. You must report any contact with law enforcement under arrest, citation, or conviction not later than the next business day after that occurs. You're to provide them with your financial information so your ability to pay any fees or costs can be reviewed. If you're referred for an evaluation or assessment for further treatment, therapy, counseling, training, educational programming, you're to submit to that. If there's a recommendation for programming, you're to enroll in and successfully complete that. You're required to comply with all the conditions in the drug court docket that the program description, which you've got, and those are incorporated in this order. You're to comply with your treatment plan as recommended. Now, by being placed on community control, you're deemed to have consented to a search without a warrant of your person, residence, vehicles owned by you or used by you, or any other property or place that's under your control, or where you're found at any time by any officer of the probation department. There'll be no suspension of your driving privileges. And have you had any change in your financial situation since the court appointed Mr. Armentrout to represent you?
No, sir. No, sir.
All right. Well, then the court will find that you do not have the ability to pay any fine and will not impose a fine. And I won't impose any suspension, driving suspension. Now, you're also ordered to pay the court costs as a substantive order, and if you don't do that, or make payment arrangements and pay in accordance with that schedule, then the clerk can collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then the court or clerk could collect that by various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then the court could order you to do community service and give you credit for each hour you work, and an hourly rate set by the court each hour you work will reduce your judgment by that amount until paid in full. Now, in the event that it's alleged that you have failed to comply with the conditions of the order, then the probation department will file a written notice of that with the court. There will be a hearing. You'll be entitled to have an attorney. If the outcome of that hearing is that you have failed to comply, then at that time the court can revoke your community control and sentence you to a prison term between 9 to 36 months and fine you $10,000. If that happens, upon completion of the prison term imposed by the court, it is possible that the adult parole authority may choose to put you under post-release control supervision for a period of up to 2 years. If they do, you'll be supervised by a parole officer on the terms they set, and if during that period of time they determine that you have failed to comply, then they can return you to prison even though you serve the entire term set by the court for an additional period of up to 9 months for any one violation, up to a maximum of half of your prison term for all violations. But if you commit a new felony, then while under post-release control, then in addition to whatever sentence a judge in the new case can impose upon you, that judge could also sentence you for committing that offense while under post-release control, in this case, to an additional period of a year or whatever time is left on that period of post-release control, whichever is greater. And if that occurs, that must be served consecutively to the sentence in the new case. All right, is there anything further from counsel?
No, Your
No,
Honor.
Your Honor.
All right, you'll be in touch, the probation department will be in touch with you then, Mr. Weil, Officer Parr, and you'll be coming to the next drug court. Well, I don't know which one, but you'll be coming in within the near future. All right,
All right.
thank you. All right. All right, case number 22 CR 223, State of Ohio versus Jamie Lee Markham. Are you Jamie Lee Markham appearing there from the jail?
No, sir.
This
Pardon?
is Marshall Smith.
Marshall Smith.
Oh, okay. Well, we'll need Mr. Markham. Mr. Smith's attorney, Mr. Kirk, is in the downstairs in a juvenile court. So if you would get Mr. Markham for me, please.
Me, Marshall.
Your Honor, Mr. Reno told me you wanted to do Robert Duell also. He's the fellow turned himself in yesterday.
Yeah, we'll do him after I do Mr. Markham.
Okay.
And Deputy, if you could get Mr. Duell to be ready next, because Mr. Kirk's going to be downstairs for a few minutes.
Yeah, he's writing the
Okay.
next board.
Great, thank you. All right, you're Jamie Lee Markham appearing there from the jail?
Yes, sir.
All right, this is case number 22, CR 223, State of Ohio versus Jamie Lee Markham. This is a hearing on a sentencing. Mr. Markham has pled guilty to assault on a peace officer, 4th-degree felony. His attorney is Danielle Witt. Representing the state is Assistant Prosecuting Attorney King. The hearing is being conducted by Zoom. And Ms. Witt, are you and your client both in agreement this matter can be conducted remotely by Zoom rather than him appearing in person before the court?
Yes, Your Honor.
All right, Mr. Markham, since you're not in court with your attorney, if at any time you need to talk to her about anything, just let me know and I can put the two of you into a breakout room or just be the two of you on the screen. The deputy will step out while you're talking, so you'll have private conversation with her, okay?
Yes, sir.
All right. So, as I indicated, the defendant has entered a plea of guilty to assault on a peace officer. There was a pre-sentence investigation ordered. I have reviewed that. Have each of the parties had an opportunity to review a summary?
State has, Your Honor.
Yes, Your Honor.
All right. Anything from the state?
Thank you, Your Honor. I would ask that the court follow the joint recommendation and place the defendant on community control. It was also part of the plea agreement that the defendant would complete mental health counseling. I understand that he feels that he doesn't need mental health counseling, but I don't really believe he's in a position right now to be able to make that determination. That's all, Your Honor.
Swit, anything you'd like to say?
Yes, Your Honor. We also asked the court to follow the joint recommendation and place Mr. Markham on community control. And I did discuss the requirements of the plea agreement with Mr. Markham. And he now understands that mental health counseling isn't an option and is willing to do whatever he's needed to as part of that requirement and as part of his probation. And this is also his first felony, so we do ask the court to follow this joint recommendation.
All right. Mr. Markham, anything you'd like to say?
Yes, sir, the rain.
Well, Mr. Markham, the fact that you don't admit that you have mental health issues is a problem. Just agreeing to do it because you have no choice isn't really an acknowledgement of what your issues are. I know that you are on Social Security for some sort of issue, but what I'm looking here is, even though this is your first offense, you have a history of being a thug and a bully. I see here last year, or 21, you had menacing and aggravated menacing. You had I can't even count how many disorderly conducts you've had, or persistent disorderly. Often those are indications of fighting. Another menacing in 15, a menacing in 13, all kinds of more and more persistent disorderly. You assaulted a peace officer, and the court takes a very dim view of anyone who assaults officers. And even though the state's has recommended, along with your attorney, that you get community control, I see that you're not a candidate for community control. I think that what your problem is you need an attitude adjustment. And particularly in view of what you just said, or what you had said, and you didn't see any reason you had to have a mental health issue treatment. So it is the order, the judgment of the court, that you be and are hereby sentenced to the Correction Reception Center at Orient, Ohio, for a period of 14 months. You'll be given credit. It looks like you were arrested originally on 11/4, and according to the sheriff's calculations, as of March 31st, that was 147 days. So 147 plus 5 today would equal 152. Now, upon completion of this prison term, it is possible that the Adult Parole Authority will place you under what's called post-release control for a period of up to 2 years. If they do, you'll be supervised under the terms they set, and if during that period of time the Adult Parole Authority determines that you have failed to comply with those conditions, then they can return you to prison, even though you serve the entire prison term set by the court, for an additional period of up to half of your prison term, which would be 7 months for one or more violations. However, if you commit a new felony, then in addition to whatever sentence a judge in a new case can impose upon you, that judge can also sentence you for committing that offense under post-release control, in this case, to an additional period of a year, or whatever time's left on that period of post-release control, whichever is greater. And if that occurs, that must be served consecutively the sentence in the new case. You're also ordered to pay the court costs, which judge grant executioner's order. If you fail to pay those, then the clerk can collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then upon completion of your prison term, not while you're in prison, but once you get out, you could be ordered to do community service in this county and be given credit for each hour you work and an hourly rate set by the court. Each hour you work, reduce your judgment by that amount till paid in full. All right, is there anything further from counsel?
No, Your Honor.
All right.
No, Your Honor.
You're remanded to custody, Mr. Markham. Would you bring in Mr. Dool next, please?
Yes, I'm ready. Good.
I don't see his arraignment entry here.
Two files, I believe.
Yeah, there are. And here it is. All right, are you Robert Dool?
Yes, sir.
All right, this, there are two cases here, 22 CR 255 and a new indictment in 23 CR 66. Mr. Dool is appearing from the Justice Center. His attorney is William Armentrout. Representing the state is Assistant Prosecutor King. With regards to case number 22 CR 225, he is charged with trespass and habitation when a person is present or likely to be present in a fourth-degree felony. And that case was previously scheduled for a pretrial, I believe, on March 22nd. There was a non-appearance, and that's resulted in a new indictment. That case was put on the inactive docket after his failure to appear. In case number 22 CR 66, the defendant was charged with failure to appear under 2937.99, 4-3 felony, alleging on or about March 22nd of 2023 in this county. He failed to appear as required in the 22 CR 255 case after he'd been released on an OR bond in connection with the commission of felony. That is a 4-3 felony. All right, now, Mr. Dool, I see you filled out your affidavit, or financial disclosure, and everything on that is correct?
Yes.
All right. The court then will find that you are indigent and appoints Mr. Armentrout to represent you. And Mr. Armentrout, how does your client plead?
Not guilty, Your Honor.
All right. All right, we will set a first pretrial on this new case. And a new final pretrial in the 255 case for April 19 at 1 p.m. And that'll be by Zoom. The final pretrial, well, actually, that first, in the 255 case, that'll be just a pretrial. Then we'll have a final pretrial for both cases on May the 3rd at 1 p.m. by Zoom. And the trial date will be set for both cases for June 12th at 8 a.m. Now, we got a matter of bond. Mr. King, the state wishes to be heard on the matter of bond.
Yes, Your Honor. The state would request, based upon the fact that the defendant failed to appear at the last pretrial, that bond be set at $5,000 in each case. I understand the defendant did turn himself in, but that doesn't change the fact that he failed to appear at his last hearing. I would also note that the defendant has a lengthy criminal history out of the states of Missouri and California. So based upon that, I do feel a bond is necessary to ensure his appearance in future proceedings. Thank you.
Mr. Armentrout?
I would ask the court, I believe that in the older case, he had posted a bond of $5,000, and I spoke to my client yesterday. I believe that he's willing to stand by that bond. We'd ask the court to reinstate that bond and release him based on his promise to appear back. He turned himself in yesterday, and it wasn't like he turned himself in from across the street. He drove in from Texas, where he's working now. He has no connections to Highland County whatsoever, except when he was working here, and that's when the first offense allegedly took place. He called me the day after he missed because his boss had asked him, did you make your video pretrial? And he responded that he forgot, and then we spoke, and I advised him the court's policy is that you don't automatically get a new hearing. You have to turn yourself in and do that process. And, he basically got back here as quick as he could and drove in from Texas. So I think that shows, good faith on his part. Like Mr. King indicated, he does have a record, but yet he drove 1,000 miles to turn himself in. And not that it matters. I think he actually turned himself in before the indictment was returned, but it all happened yesterday. He asked the court to take that into consideration.
All right. Well, I recall at the arraignment, Mr. Dool, I was very specific about your requiring to be appearing because I knew you were going to be working out of state, and I believe I even warned you about that. And the fact that you just forgot it doesn't give the court much confidence. And you're a resident of the state of Maryland. Apparently you were in Texas. You failed to appear on the 23rd, I believe it was. and you turned yourself in apparently on the 4th. That'd be 12 days. It doesn't take 12 days to drive from Texas to back here.
You
Obviously,
gotta make the money be
I
able
didn't
to
ask
make
you
it.
to speak. You just be quiet. I'm talking. And so, based on that, it's the order of the court that your bond in case number 22 CR 255 be set at $15,000 plus your own recognizance and an additional $171 deposit prior to release. And in case number 23 CR 66, $5,000 plus $171 deposit for the statutory required fees prior to release. If you make bond, you'll be under the same conditions as previously ordered. You'll report to the probation department at 117 East Main Street. Report to them once a week for 4 weeks. After that, as they determine, undergo random drug testing. Provide phone numbers for home, cell, employer. If recommended by probation, be evaluated for substance abuse and mental health issues, and treatments indicated, enroll in and follow that during pendency of this action. You're going to be under house arrest at your residence, meaning you have to be there at all times, unless you're working, going to and from work, medical appointments, court proceedings, appointment with an attorney, probation officer, in this or any other case, or church services, and you may not leave the state of Ohio in either case. It's shown that when you do, you don't come back, you don't pay attention to your court hearing, so you'll be required to remain in the state of Ohio if you make bond. All right, thank you. All right.
Marshall Smith.
You want Marshall Smith next?
Yeah, Marshall Smith. Okay, case number 22 CR 244, State of Ohio versus Marshall Smith. You're Marshall Smith appearing there from the jail.
Yes, sir.
All right. Mr. Smith, this is a hearing being conducted by Zoom. He has entered a plea of guilty to aggravated possession of methamphetamine. This is a sentencing hearing. His attorney is Dennis Kirk, appearing on his phone, appearing from the prosecutor's office, Assistant Prosecutor King. This is a 5th-degree felony. The court-ordered pre-sentence report, I've received a copy of that, or I have received that and reviewed that. Have each of the attorneys had an opportunity to review a summary?
It has, Your Honor.
I have not, Your Honor.
All right. Mr. King, anything on behalf of the state?
Only what's contained in the plea agreement, Your Honor.
Oh, Mr. Smith, before I go any further, Mr. Kirk, you and your client are both agreeable to this hearing being conducted by Zoom rather than in person?
Yes, Your Honor.
All right. You're all right with that, Mr. Smith?
Yes, sir.
All right. Now, if at any time during this proceeding you need to talk with your attorney, just let me know. I'll put the two of you into a breakout room. It'll basically be the two of you on the screen talking. The deputy will step out of the room there so you can talk with him privately, okay?
Yes, sir.
All right. And there's nothing from the state regarding sentencing?
No, Your Honor.
All right. Mr. Kirk?
Thank you, Your Honor. After the last hearing, my understanding is the probation department did complete an assessment, and I believe there is a STAR bed available on April 19th. So my client met with him yesterday. He's open to whatever the court would recommend as far as residential treatment or STAR. So we would ask the court to grant community control with whatever additional sanctions the court would feel appropriate.
Anything you'd like to say, Mr. Smith?
No, sir.
What is he being held for now at the jail?
Just on this case here, he did not complete his PSI.
Well, did we issue a case before him?
No, he came to the sentencing hearing and the court sentenced him to remanded him to custody.
Oh, that's right. Okay. I forgot about that. All right. I did order his bond revoked. Yeah, I did when he came in. All right. Well, Mr. Smith, you've not done a real sterling job of convincing me you're going to be compliant with community control. You know, you do have prior numbers, And, you know, you didn't cooperate at all with probation and, you know, coming in for a pre-sentence report or anything until I ordered you to be arrested, put in jail. And then at that time, they were able to talk with you about this matter. But given that this is a 5th-degree felony, I'm going to give you one chance to prove that you're serious about turning your life around. And so it is the order of the court you be sentenced to a term of 3 years of community control under these conditions. You're to obey all laws of all jurisdictions, conduct yourself in law-abiding manner at all times, report when and as directed, be truthful in all statements you make to the probation department, keep them informed of your residence, place of employment at all times. You may not change either without prior permission. You're not permitted to leave the state at any time without prior written permission. May not enter upon the grounds of any correctional facility, nor communicate with or attempt to communicate with anyone who's an inmate in those facilities without prior written permission. Because of your convictions, you're prohibited under both federal and state law from purchasing, possessing, owning, using, or having under your control any kind of a firearm, ammunition, or dangerous weapon, and it's a violation of these conditions as well should you do that, or if you should have any other weapons of any other type, you're not permitted to have those either. You're not permitted to purchase, possess, use, or have under your control a controlled substance, drug abuse, CBD oil, kratom, or any variant analog of any controlled substance that has effects similar to controlled substances or drugs of abuse, or any instrument, device, or thing that may be used to administer them, prepare them for administration unless you have a lawful prescription, a copy of which must be provided to your supervising officer within 24 hours of receipt. The lawful prescription doesn't include medical marijuana cards. Medical marijuana are not issued by prescription. They're issued by a fiction created by the state to get more money, and you're not permitted to do that while you're on community control. You're to submit to drug testing when and as directed. You may not purchase, possess, use, or have in your control any kind of alcoholic beverage, nor may be present in places where they're sold or being consumed, even as otherwise lawful. Not to associate with anyone who's a co-defendant in this case, or any other person who has a criminal record as a member of a gang, or any other criminal group, or any person who has in the past or could in the future influence you to commit a criminal offense or violate these conditions, unless that's approved in writing by your supervising officer. After the date of this order, you may not marry or establish cohabitation in a common law marriage type relationship with another without written permission. You must report any contact with law enforcement, any arrest, citation, conviction, or other charge of violating the law not later than the next business day after that occurs. If you're referred by probation for any evaluation or assessment for further kind of programming beyond that ordered by the court, you're to submit to that, and if there's programming recommended, you must enroll in and successfully complete that. Be required to pay the court costs of this action, make payment arrangements. You'll be required to do 400 hours community service, rated 20 hours per week for 20 consecutive weeks, unless you're employed, at least 20 hours a week, full-time student, or it's documented you have a prior disability finding or a letter from a physician that you're not able to do that. Now, you've been accepted into the STAR program. There's a bed date available Wednesday, April 19th. So it's ordered that you successfully complete the STAR program and any recommended aftercare. You'll remain in the county jail until you are conveyed to the STAR, and that is April the 19th. Now, by being placed on community control rather than being sentenced to prison, you're deemed to have consented to a search without a warrant of your person, your residence, places that are owned by or controlled by you, or any other property where you're found at any time by any officer of the probation department. You'll not be required to pay any fine. There'll be no license suspension. The court order to pay court costs is a substantive order, and if you don't make payment arrangements and pay in accordance with that plan, then the clerk can collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then upon completion of the then the court could order you to do additional community control, community service, and give you credit for each hour you work in an hourly rate set by the court. Each hour you work, reduce your judgment by that amount until paid in full. That would be in addition to the community service that you're already required to do. Now, in the event that it's alleged that you are not compliant with these conditions, the probation department can file a written notice of that with the court, serve a copy on you. There'll be a hearing. You'll be entitled to have an attorney. If the outcome of that hearing is that you have failed to comply, the court can then at that time revoke and sentence you to prison for between 6 and 12 months. And if at the completion of that term, the parole authority determines that they should do it, they can put you under post-release control for a period of up to 2 years under terms they set. If they determine you fail to comply, they can return you to prison for up to half of the prison term imposed for one or more violations. But if you commit a new felony, then in addition to whatever sentence the judge in that new felony could impose, that judge could also sentence you for committing that violation while under post-release control in this case to an additional period of a year or whatever time is left on that period of post-release control, whichever is greater. And if that occurs, that has to be served consecutively the sentence in the new case. All right, is there anything further from council?
No, Your Honor.
All
No,
right.
Your Honor.
You're remanded back to custody then.
Thank you, Your Honor.
All right, Mr. Kirk, Mr. Blanton is here, and I'll All right, this case number 22, CR 171. State of Ohio versus Bobby Foster. You're Bobby Foster appearing there on the screen mark. I don't know if that's Clemens or C. Lemons, but
It's Clemens.
Clemens, all right.
Yeah.
All right, and Ms. Foster's attorney is Ms. Barger. And the state's represented by Mr. King, the assistant prosecuting attorney. Now, this matter was put on the docket. It says it's for an intervention plea, but I don't have any paperwork on that. Has there been any paperwork submitted?
Yes, Your Honor. The plea form, this was originally set for an ILC plea on March 8th, and the plea form was provided to the court on that day.
Okay. Would you go pull the PSI then? That's where it is, PSI file. All right, for the record, I have received a report from Soda Paint Valley Mental Health Center indicating that Ms. Foster is in treatment at the Lynn Goff Clinic. Went there on March the 9th. Anticipated discharge would be June 7th. That she has been compliant. All right. So, Ms. Foster, I'm sure that your attorney has explained this to you, but I'm required to make sure that you understand what's going on. Generally, when a person pleads guilty, which is what's proposed here, the court finds that person guilty and then imposes a sentence, which can be prison term. In your case, could be between 6 and 12 months. There also could be a fine of $2,500. It could also be a license suspension of 6 months to 5 years. And I forgot, is she pleading guilty to one or both charges?
Both counts, Your Honor.
Okay, so that means it'll be a possible prison term of maximum 24 months, a maximum fine of $5,000. Now, once that happens, and then there also could be community control or probation. It could be a fine as well, as I said, and there could be a license suspension of 6 months to 5 years. Now, should that happen, and when that type of thing happens, then that person has a felony conviction. There is a procedure, however, under the law, which is being recommended here, that instead of, that because of your drug addiction and use, that was a primary factor in your commission of these offenses. And then because of that, if you, assuming that you're eligible under the law, which as I recall, I believe you were, you plead guilty, but the court doesn't find you guilty. Instead, the written plea of guilty is filed with the court file, and you are referred for a period of, could be up to 5 years. I usually order 2 years of treatment. And you are required to complete the treatment plan. One of the legal requirements is that you must remain drug and alcohol free for a minimum of 1 year. And then in addition to that, you must comply with the other portions of your treatment plan, as well as the conditions of supervision that the court orders. And the conditions for supervising someone on intervention in lieu are less strict than if you were convicted of a felony and found guilty and sentenced. The advantage of that program is that if you complete the program and you comply with the court's orders, then upon notice of that from the probation and the prosecutor's office, the case is dismissed. And so even though you pled guilty, you were never found guilty. And even if somebody looks at the file right now for the next 2 years and sees that you pled guilty, you still are not a convicted felon, because until there's a sentencing entry filed in the case, there's no conviction. And the advantage to you is that if you do these things and comply with your treatment program and comply with the conditions, then at the notice of that from the probation department and the prosecutor's office, the case is dismissed. So even though you pled guilty, it's dismissed and you're never found guilty. And then the court will set the matter for a sealing hearing, and unless you've committed a new crime in that period of time, the court would seal the record, which means that it would not be in the public records anymore. It would be removed from the public records, and you would be able to answer honestly to anyone who asks, no, I do not have a felony conviction. And that's the big advantage to you. Now, the disadvantage is that this is your last chance to stand on a not guilty plea and contest the charges. And so, because if you go through go into the program and you don't comply with either your treatment plan or the conditions or both, then when you come back to court, we do have a hearing on that. They have to allege that. Probation has to file written notice of that, and we have a hearing, and you are represented by an attorney at that hearing. If the outcome of that hearing is that you fail to comply, then at that time the court finds you guilty and then proceeds with sentencing. Now, the sentences I indicated for these offenses could be 6 to 12 months on both charges, so it could be a maximum of 24 months. There could be a fine of $10,000. It could be a license suspension of 6 months to 5 years. Or there could be community control, which is probation. And that could be for up to 5 years as well, but those conditions are much different. They're much more strict. But basically it would be a second chance, so to speak. Again, in that event that you fail to comply with those conditions, then the probation department would file a notice of that with the court, serve a copy on you. There'd be a hearing at which you could be represented by an attorney. And at that time, if the outcome was that you failed to comply, then the court could revoke your community control and then sentence you to the 24 months, anywhere from 6 to 24 months, fine you $10,000. And if that occurred, then upon completion of the prison term, it would be possible that the Adult Parole Authority may choose to put you under post-release control for a period of up to 2 years. By the way, Mr. King, I just noticed in this plea form, it still says 3 years. So you might want to make a note on page 2 that needs to be changed to 2, and I'm making that change by ink right now on the record.
Yes, sir.
And what that means is you'd be supervised by a parole officer under the terms of the APA, and if they determine that you fail to comply, then they could return you to prison even though you serve the entire term set by the court for a period of up to 9 months for any single violation, but there is a maximum or cap of half of whatever prison term you served for all violations. But should you be convicted of a new felony, then in addition to whatever sentence a judge in the new case could impose upon you, the judge could also sentence you for committing that new felony while under post-release control, in this case, to an additional period of a year or whatever time is left on that period of post-release control, whichever is greater. If that occurred, that must be served consecutively the sentence in the new case. Now, I do have the plea form. Well, let me back up. Do you understand that?
Yes.
All right.
Yes, sir.
Now, I do have the plea form. I'm going to hold it up here to the camera and make sure you recognize that that's your, the plea form says you're going to plead guilty to both of these charges.
Yes.
And there are on page 3, there are signature lines. At the top of the page, there's a sentence that reads, I enter this plea voluntarily. And I see right below that a signature defendant from January 24, 23. And is that your signature, Bobby Foster, there, right underneath that?
Yes, sir.
All right, now that's been about almost 2.5 months. Is this still what you want to do?
Yes, sir.
And when you sign this, you understand then and now that it's an agreement to plead guilty, which means there's not going to be a trial. And the next step would be for the court to order you into the intervention program.
Yes. Yes, sir.
All right. And Mr. King, there's not a signature on this, but the state's in agreement with this, right?
Yes, sir, Your Honor.
All right. Now, did you have enough time to fully consider this matter before making that decision?
Yes.
And do you feel that you were coerced in any way into doing this?
No, sir.
You entered into this agreement voluntarily, and you're entering your agreement to plead guilty today voluntarily?
Yes, sir.
All right. Now, the charges in the indictment are that, count 1, that on or about January 13, 2022 in this county, you did knowingly obtain, possess, or use a Schedule 2 controlled substance with methamphetamine, violation 2925.11 of the Ohio Revised Code. Count 2 alleges the same thing, same date, except that it was an oxycodone, but otherwise everything's the same. same section number. Both of those are fifth-degree felonies with the penalties I've described. Now, Ms. Foster, do you understand what it is you've been charged with, what the state said you did, when, where, and how they alleged you did it?
Yes, sir.
And you understand the possible penalties for these offenses if convicted and sentenced?
Yes, sir.
And have you discussed the nature of the charges, the evidence in the case, possible legal issues in the case, possible defenses you might try to raise at trial, and the possible outcomes of a trial with your attorney?
Yes, sir.
Are you satisfied with her advice and competence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Has anyone threatened you to make you plead guilty here today?
No, sir.
Other than being promised that you would be put into the intervention in lieu of conviction program rather than sentenced, has anyone promised you anything to get you to do this?
No, sir.
Do you hold any license or certification from any state agency that regulates any occupational profession?
No, sir.
Right now, under the law, as I indicated, this is your last chance to stand on your not guilty plea, so you must understand the consequences if you enter a plea of guilty, possible consequences if down the line you are found not to have complied with the program and are found guilty. So, first of all, you have a right to counsel. Ms. Barker was appointed to represent you, not simply to work the case out, but to provide any defense that might be available to you under the law that you'd like her to provide. And so, if you decide you don't want to do this, you want to defend the charge, including a trial, then you'll continue to have legal representation to do that. You understand that?
Yes, sir.
Now, under the Constitution, you're entitled to have a jury trial on these charges in which 12 people will be selected from a group of citizens that live in Highland County that are selected for jury duty on your trial date. After they are selected, the evidence will be presented, they'd be instructed on the law, and that jury would decide by unanimous verdict, meaning all 12 would have to agree, on each count as to whether the state proved your guilt on either or both counts. If you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive or give up in writing your right to have a jury trial, which means that instead you would have a court or bench trial in which the judge would be the one who would hear the evidence instead of a jury, and the judge would apply the law and decide whether or not the state proved your guilt. Do you understand that?
Yes, sir.
Now, in the Constitution, you have a right to confront the witnesses against you and to cross-examine them through your attorney. What that means, the witnesses against you have to come into court and testify in front of you, your attorney, and anyone else is present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination, the purpose of which is bring out evidence that helps your side of the case. Do you understand that?
Yes, sir.
Now, in the Constitution, you have a right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, the same as the state. So if you have witnesses you're not certain are going to come in voluntarily, at your request, the court issues a court order called a subpoena, and that forces those people to come to court to be available to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are forced to come into court and testify against you. Do you understand that?
Yes, sir.
All right, now, under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including the trial. So no one can ever make you testify. The prosecutor can't, the judge can. It's your decision. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person, and no one's even allowed to comment about it except in one situation, and that is, if there's a jury trial and you do not testify, the judge instructs the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
All right, now in the Constitution, you have a presumption of innocence, which means that you're presumed innocent until proven guilty by the state of Ohio on each of these charges. Excuse me a second. I just realized I'm going to be going. And if we do this premise today, we're going to have bond hearing Friday morning. So we're going to do it tomorrow. Find a time tomorrow. And then we need review Monday. All right, and so you have the privilege against self-incrimination, as I indicated, which means that you cannot be forced to give evidence at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can, it's up to you. And if you decide not to testify, the fact you did not testify cannot be used against you at any time, in any way, in the proceedings, except in one situation. If there's a jury trial and you don't testify, the judge does instruct the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
Now, under the Constitution, you're presumed innocent until proven guilty by the state of Ohio on every essential element of the offense charge. So what that means is the burden of proof isn't on you to try to prove you're not guilty because you've been accused. In fact, under the law, you're not required to present any defense, evidence in defense of yourself at trial. You may, but you're not required to. Well, regardless of whether you put in evidence in your defense or not at trial, the burden of proof remains on the state to prove your guilt by proof beyond a reasonable doubt on every essential element of each of the offenses, which is the highest burden of proof that's known under the law. Do you understand that?
Yes. Yes, sir.
All right, now originally you entered a plea of not guilty, which denied the allegations in both counts, denied you committed any crimes, and exercised or invoked all the rights I've just described. If you change your plea from not guilty to guilty, then that is the opposite of the not guilty plea. Guilty plea admits the allegation in each count of the indictment, admits that they're a crime, that you committed those crimes, and that plea to each charge, I should say, would waive or give up all the rights I've described for you today, except the right to have counsel. You always have the right to have counsel or attorney at any time, regardless of your plea. But with that exception, your plea of guilty would waive or give up your right to a jury or court trial, would waive or give up your right to confront witnesses in open court and to cross-examine through your attorney, would waive or give up your privilege against self-incrimination because you're saying you're guilty. That's what's used to find you guilty, or in this case, to put you into intervention. And it waives or gives up your presumption of innocence because if you say you're guilty, the state doesn't have to prove you're guilty. It does subject you to being sentenced immediately by the court if I thought that was the right thing to do instead of giving you intervention. That's not what I'm going to do, but that is a legal consequence. And it also waives or gives up any right to file an appeal you think you may have had up until this point in the case. Now, if you should at some time in the future be sentenced to the maximum sentence or under certain circumstances you can file an appeal, that would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Yes, sir.
And are you a U.S. citizen?
Yes, sir.
Now, do you have any questions about the intervention in lieu of conviction program or what will be expected of you?
No, sir.
Do you understand that?
Yes.
Do you have any questions about the plea agreement?
No, sir.
You understand that?
Yes, sir.
Any questions about the constitutional rights I've explained?
No, sir.
You understand those?
Yes, sir.
Have any questions about the plea of guilty, what it means, what will happen if you enter that plea here today?
No, sir.
You understand that?
Yes.
Is there anything you need to speak with Ms. Merger about before we go any further?
No, sir.
You have any questions at all about anything I've explained here this morning?
No, sir.
Then is it your decision to withdraw your not guilty plea and plead guilty to the charge, two charges in the indictment pursuant to the terms of this agreement that we've just gone over?
Yes, sir.
All right, then as to count one, which alleges that on or about January 13, 2022 in Highland County, Ohio, you did knowingly obtain, possess, or use a Schedule II controlled substance with methamphetamine in violation of Section 2925.11, Revised Code, a charge of aggravated possession of methamphetamine, a fifth-degree felony, carrying possible prison term between 6 to 12 months, fine $2,500, license suspension of 6 months to 5 years. How do you plead?
Guilty.
Guilty?
Guilty, yes.
Okay. Count two, which alleges on or about the same date in this county, you did knowingly obtain, possess, or use a Schedule II controlled substance with oxycodone, also violation of Section 2925.11 Higher Revised Code, the same offense, same penalties. How do you plead?
Guilty.
All right, the court finds that on this day in open court, the defendant was advised of all of her constitutional rights, made no intelligent voluntary waiver of the same pursuant to Criminal Rule 11. Please accept an order filed. The court finds that this defendant's drug dependence was a factor that led to the criminal activity with which he's been charged, and rehabilitation through treatment will substantially reduce the likelihood of any criminal activity. She is accepted into an appropriate certified treatment program at the Lynn Goff House and is otherwise eligible for immediate control sanctions. She's not a repeat or dangerous offender and is otherwise eligible for intervention in lieu of conviction. Therefore, it's ordered and decreed that her plea of guilty be accepted, but that the criminal proceedings will be stayed. There will be no finding of guilt at this time. The defendant will be placed under community control supervision under the terms set by the court for the probation department program for a period of 2 years. She successfully complete her intervention plan, including requirement that she abstain from using drugs or alcohol for a period of at least 1 year. She must comply with all the terms and conditions set forth by the probation department that have been previously approved by the court. She's to pay the court costs of this action and any programming fees. Should she successfully complete the intervention plan and obey all the conditions of her community control, then upon notice of that from the state, the court will dismiss the proceedings against the defendant, set the matter for a sealing hearing. However, if she fails to comply with any of the conditions or her treatment plan, upon written notice of that from the probation department, the court will hold a hearing to determine whether she has failed to comply, at which time she'll be represented by counsel. And if there is a finding that she's failed to comply, at that time the court could revoke the intervention, find her guilty, and could order her to be incarcerated for a period of 6 to 24 months and fine $5,000 and a license suspension of 6 months to 5 years. If that should happen, prison term, then upon completion of the prison term, the Adult Parole Authority could put you under post-release control as part of that sentence, and meaning you'd be supervised for an additional period of up to 2 years under the terms they set. And if they found that you failed to comply, then at that time they could require you to serve an additional period of up to 9 months for a single violation, or a cap or limit of half of your prison term, whichever is greater. I'm sorry, or, up to half of your prison term for all violations. However, if you're convicted of a new felony, then in addition to whatever sentence the judge in that new case could impose, the judge could also sentence you for an additional period of up to of 1 year, or whatever time's left on that period of post-release control, whichever is greater, for committing that offense while under post-release control in this case. And if that happens, that would have to be served consecutively in sentence in the new case. All right, is there anything further from counsel?
No, Your Honor.
All
No,
right.
Your Honor.
All right. Thank you. All right, Mr. King, if you could come on over, Mr. Kirk and his. Are you Mr. Barger there on the screen marked J.U. Young? We're going to do your hearing in a few minutes. I've got another hearing here in the courtroom, and then as soon as we get done with that, we'll do your hearing. You can just keep your screen muted there, please. All right, this is case number 2316, State of Ohio versus Joseph Glenn Blanton. Appearing on behalf of the state's Assistant Prosecutor Adam King, appearing on behalf of the defendant's attorney Dennis Kirk, and you are Joseph Glenn Blanton.
Yes, sir.
All right, Mr. Blanton has entered a plea of guilty to aggravated trafficking in a fentanyl-related compound, a third-degree felony in violation of Section 2925.0382. The matter was continued for sentencing to today's date. There was no PSI ordered. There was a recommendation of a 12-month sentence. All right, Mr. King, anything on behalf of the state?
Only was contained in the plea agreement, Your Honor.
All right, Mr. Kirk.
Thank you, Your Honor. I would ask court to follow the plea agreement. We do have a unique situation in this particular case. My client has some GI or colon issues going on, and we did advise the court of that back at the plea, and that's one of the reasons it was set for today, to kind of get a status as to what's going on. He has an appointment with a Dr. Braveman at Ohio Health. They are a colon and rectal surgery group. That appointment, according to the verification card he provided me, is April 17th. That's supposed to be the pre-surgery appointment, and then he's at that time would be given a date for the colon surgery. He advised me that when he passes stool, that his intestines drop out partially. So that's what the purpose of the surgery is, to correct that. They're advising it'll be major surgery. So just making the court aware of that and its passing of sentence. Thank you.
All right, Mr. Blanton, anything you'd like to say?
No, Your Honor.
For some reason, I do not have a copy of the compliance with discovery in this matter. What is the defendant's prior record, if any?
2007, Your Honor, the defendant was convicted of felony 5 possession of heroin, felony 5 possession of crack cocaine. 2013, the defendant was convicted of felony 2 robbery in Franklin County, and also convicted of felony 5 trafficking and having weapons under disability in 2013.
Okay. All right. Give that, Judge. All right, it's the order of the court the defendant be and is hereby sentenced to a term of 12 months of incarceration at the Correctional Reception Center or in Ohio. And according to the sheriff, you served 1 day in jail when you were arrested on February 6th. Is that correct?
Yes, Your Honor.
All right, so you'll be given 1 day of jail time credit. Now, upon completion of that sentence, the Adult Parole Authority may choose to put you under post-release control for a period of up to 2 years. They don't have to, but they can, but it's up to them. If they do, you'll be supervised on the terms they set for a period of up to 2 years, and if during that period of time they determine that you have failed to comply, they can return you to prison to make you serve an additional period of 1 year or whatever time's left. They can make you serve up to half of the prison term, which is 6 months, for one or more violations. However, if you're convicted of a new felony, then in addition, whatever sentence a judge in that new case can impose upon you, that judge is also authorized to sentence you for committing that offense while under post-release control, in this case, to an additional period of a year or whatever time's left on that period of post-release control, whichever is greater. If that occurs, that must be served consecutively to the sentence in the new case. Now, it's also ordered that you pay the court costs, which judge will grant execution is ordered. If you fail to do that, then the court clerk could collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then upon completion of your prison term, not while you're in prison, but once you get out, you can be permitted to do community service in this county and be given the credit for each hour you worked and an hourly rate set by the court. Each hour you work will reduce your judgment by that amount until paid in full. There will be no license suspension, and has there been any change in your financial circumstances since you were appointed counsel in this case?
No, Your Honor.
All right, then the court will find that the defendant does not have the means to pay the mandatory fine, is not likely to have it in the near future, therefore that will be waived. All right, is there anything further from counsel?
No, Your Honor.
All right, you're remanded in custody, Mr. Bland.
I guess what you'll need to do is when you get to the corrections reception center, let them know.
All right, Mr. Barr. Lower corner. You go ahead and go, Mr. All right. Are you Joshua Allen Barger, appearing there on the screen marked J.U. Young?
Yes, sir.
All right. This is case number 23 CR 006, State of Ohio versus Joshua Allen Barger. Mr. Barger is appearing by Zoom from the counseling center. His attorney is Danielle Witt. She's appearing from her office by Zoom. Appearing from the prosecutor's office is Assistant Prosecutor King. This is a proposed plea of guilty granting intervention in lieu. Ms. Witt, are you and your client both agreeable to him appearing by the means of remote technology using Zoom rather than his personal appearance in the courtroom?
We are, Your Honor.
And you're in agreement with that, Mr. Barger?
Yeah, that's fine with me.
All right. The defendant is charged with aggravated possession of a fentanyl-related compound, a fourth-degree felony. He has filed his motion for intervention in lieu of conviction. I have the proposed guilty plea here. I did order a report which doesn't have a staple in it, and it just fell apart on me. And let me look at it here. All right, defendant doesn't have any prior convictions, and he had started out at Massey House and had been to recovery counsel, but was determined he needed an upgrade treatment. So you're now at the counseling center in West Union, is that correct?
Yes, sir.
All right. All right. Then it does. Court does find the defendant is eligible for intervention in lieu of conviction, and it has been stipulated to by the parties. Now, Mr. Barger, I have this plea of guilty form here, but before I go over it, let me explain something to you. Your attorney probably did this, but I have to go over and explain it to you on the record. First of all, you have a right to have, first of all, normally, if somebody pleads guilty or is found guilty after a trial, then that person is sentenced. And that could be a prison term, in this case, between 6 and 18 months. It could also be a fine of up to $5,000, and there could be a license suspension of 6 months to 5 years. If that happens, then that person does have a felony conviction. And it could also be community control, as I said, or probation for up to 5 years. Now, there's a provision in the law that provides that if a person's substance use disorder and abuse was a contributing factor to the commission of a criminal offense, then if that person gets into an accepted certified treatment program, and you are in one now, and successfully completes that program and also complies with conditions of community control for up to 5 years, then upon completion of that, the case is dismissed. And then even though that person entered a plea of guilty, they were never found guilty, because until you're actually sentenced and found guilty and sentenced, there is not a felony conviction, even though there's a felony or there's a plea of guilty in the file. And so you can, and if you are successful, then the court sets the matter for a sealing hearing to seal the record, and which I always do unless the person picks up a new felony. And then at that time, it'll be removed from all the public records, and you can say honestly to any person or any background check of any sort, application of any sort, that you do not have a felony conviction. Now, the terms of that supervision are set by the court, and an entry I filed a number of years ago that established this program. Those terms are not as significant, as restrictive and comprehensive as if you were put on regular community control and after being sentenced. And so that's your opportunity to avoid a conviction if you successfully complete your treatment plan. Now, it can be up to 5 years. I order 2 years. And one of those components of that was required by statute is you must remain alcohol and drug free for at least 1 year. But if you do all that, then you won't have a felony record. Do you understand that?
Yes, sir.
All right. Now, this agreement says that you're going to withdraw your not guilty plea, plead guilty, and be granted intervention in lieu of conviction. And I'm going to hold it up to you, the first page, just to make sure you recognize that form. See that there?
Yeah.
Okay. And on page 3, there is a sentence at the top of that says, "I enter this plea voluntarily," and immediately below that there's a signature line which appears to say Joshua Barker, and I'll hold that up to the screen and again, Cameron, and ask you if that is your signature. I'm sorry.
Yeah.
Right there.
Yes, dear.
Okay, sorry. Now, when did you sign this agreement, Mr. Barger?
When I was over at Recovery Council.
Okay, so that's been a while, about a couple, 3 weeks.
Yeah, yeah.
All right, and at the time you signed this, did you understand in this agreement to plead guilty in the matter?
Yeah.
And you had discussed that with your attorney before you signed it?
Yeah, we discussed, yeah.
All right. And did you sign this agreement voluntarily?
Yes.
And do you still wish to go forward with this and plead guilty today voluntarily?
Yes.
All right. Now, the agreement states you're going to plead guilty to the charge, which is aggravated possession of a fentanyl-related compound in violation of Section 2925.11, fourth degree felony. Further states you understand the maximum penalty for that could be between 6 and 18 months in prison, a fine of $5,000, and a possible license suspension of 6 months to 5 years. And it could also be community control instead. You understand that?
Yes.
And you're not facing any felony charges anywhere else?
No.
And you're not on probation, community control, parole, or post-release control for a felony?
No, sir.
All right. Now, under the law, if you are granted intervention, it will be for 2 years under those conditions that I mentioned. And if during that period of time the probation department feels that you're not complying, they will file a written notice of that with the court, and there will be a hearing. You will be represented by an attorney at that hearing. If you can't afford to hire your own, then the court will appoint one for you. If the outcome of that hearing is that you have not complied, then at that time the court can revoke you from intervention in lieu of conviction, and then you will be found guilty. And at that time, the court could impose a sentence of between 6 and 18 months in prison, a fine of $5,000, a license suspension of 6 months to 5 years. Now, if that happens, once you complete the prison term imposed by the court, it is possible that the Adult Parole Authority would put you under post-release control supervision under that sentence for a period of up to 2 years. It's up to them. They don't have to, but they can, and if they do, you'll be supervised on the terms they set. And if they determine that you have failed to comply, then they could return you to prison, even though you serve the entire term set by the court, for an additional period of up to 9 months for one or more violations. That would also be the cap. Couldn't be any more than 9 months. However, if you are convicted of a new felony while under post-release control supervision, then in addition to whatever sentence a judge in that new case could impose, that judge could also sentence you to an additional term, in this case of 1 year, whatever time's left on that period of post-release control, whichever is greater, for committing that offense while under post-release control. And if that occurred, that would be served consecutively the sentence in that new case. You understand that?
Yes, Your Honor.
Now, under the law, even if you are found to have failed to comply with the intervention program, and I revoke you and find you guilty, at that time it wouldn't have to be a prison sentence. It could still be community control. As I indicated earlier, community control can be for a period of up to 5 years, and it's supervision under the probation department under terms that are set by the court that are more restrictive and more comprehensive. And the same thing applies as in intervention. If during the period of time you were being supervised, they felt you were non-compliant, they would file a written notice of that with the court, give you a copy. There would be a hearing at which you could be represented by counsel, and if the outcome of the hearing was that you failed to comply, then at that time the court could revoke your community control and then sentence you to prison for 6 to 18 months, fine you $5,000. Do you understand that?
Yes, sir.
Now, the charge in this case alleges that on or about October 21, 2022 in this county, you did knowingly obtain, possess, or use a Schedule II controlled substance, to wit, a fentanyl-related compound, an amount equal to or exceeding 1 gram but less than 5 grams, in violation of Section 2925.11. So that's the charge of the 4th degree felony, aggravated possession of fentanyl-related compound, carries a prison term and a fine and a license suspension I explained earlier. Now, do you understand what it is you've been charged with, what the state said you did, when, where, and how they alleged you did it?
Yes, sir.
And have you discussed the nature of the charges, the evidence in the case, possible legal issues in the case, possible defenses you might try to raise in trial, and the possible outcomes of a trial with your attorney?
We haven't went into detail, but I'm aware of all of it.
All right. So you're satisfied with her advice and confidence in this matter?
Yes.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Has any threats been made to make you plead guilty today?
No, sir.
Other than being promised to be put into the intervention program, has anyone promised you anything to get you to plead guilty?
No, sir.
Now, before I can accept your plea, I have to explain to you your constitutional rights, because this is your last chance to stand on a not guilty plea and to contest the charge. Because if you go into the intervention program and you don't succeed and you're revoked, you don't get to come back and say, okay, I tried but it didn't work, so let's have a trial. You have to, if that happens, you'll just be found guilty and then be sentenced. So that's why we have to explain this to you at this time. Now, let me go back. Do you hold any license or certification from any state governmental agency that regulates any occupation or profession?
No, sir.
All right. Now, under the law, you have a right to have a jury trial on this charge, in which 12 people would be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. After they are selected, the evidence would be presented, they'd be instructed on the law, and that jury would decide by unanimous verdict on whether the state proved your guilt of the charge. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive in writing, which means to give up, your right to have a jury trial, and in that case, you would have what's called a court or bench trial. And that means instead of a jury hearing the evidence, the judge would hear the evidence, the judge would apply the law, and the judge would decide whether or not the state proved your guilt of the charge. Do you understand that?
Yes, sir.
Okay. And again, I don't know if I said it, but on a jury trial, all 12 jurors would have to agree. You understand that?
Yes.
Right, under the Constitution, you have a right to cross-examine the witnesses against you in open court and to confront them in open court. What that means is the witnesses against you have to come into court and testify in front of you and your attorney and anyone else is present. After the prosecutor's done asking questions of the witness, then your attorney can ask questions of that witness and each witness, and that's called cross-examination, and the purpose of that would be to bring out evidence that would help your side of the case. Do you understand that?
Yes, sir.
Right now, you have the right to use the power of the court to compel or force witnesses to come into court and testify on your behalf, the same as the state. So if you have witnesses you're not certain are going to come in voluntarily, at your request, the court issues a court order called a subpoena. And that forces those people that are named in that subpoena to come to court, be available to testify on your behalf if you want them to, even though they don't want to be here, which is the same way the state's witnesses are required to come to court to testify against you. Do you understand that?
Yes, sir.
All right, now under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't. That is totally up to you. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time in the proceedings, and in fact, no one can even comment about it, with one exception. If there's a jury trial and you don't testify, the judge instructs the jury that because it is your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
Right now, under the Constitution, you have a presumption of innocence, which means that you're presumed innocent until proven guilty by the state of Ohio on every essential element of the offense charged. So the burden of proof isn't on you to try to prove you're not guilty simply because you've been accused of this crime. In fact, under the law, you don't have to present any evidence at all at your trial. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state to prove your guilt by proof beyond a reasonable doubt on every essential element of the offense charged, which is the highest burden of proof that's known under the law. Do you understand that?
Yes.
Now, originally entered a plea of not guilty plea denied the allegation of the indictment, denied you committed any crime, and exercised or invoked all the rights I described. If you change your plea from not guilty to guilty, that is the opposite of the not guilty plea. The guilty plea admits the allegations in the indictment, admits that they're a crime, but you committed that crime. And that plea waives, gives up all the rights I've described for you today, except the right to have an attorney. You always have a right to have an attorney no matter what your plea. But with that exception, your plea of guilty waives, gives up your right to a jury or court trial. Waives, gives up your right to confront witnesses against you and to cross-examine through your attorney. Waives, gives up your right to use the power of the court to compel or force witnesses to come to court to testify on your behalf, the same as the state. It waives, gives up your privilege against self-incrimination because you say you're guilty, that's what you define as guilty. it waives gives up your presumption of innocence, because if you say you're guilty, the state doesn't have to prove you're guilty. It also subjects you to being sentenced immediately by the court. And finally, it waives gives up any right to file an appeal you may have had up until this point in the case. Now, if I sentence you the maximum sentence, or under other certain circumstances, you can file an appeal. Any appeal that you want to file would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Yes, sir.
And are you a U.S. citizen?
Yes.
Now, do you have any questions about the intervention in lieu program, or what will be required of you, or what the consequences of that will be if you're in that program?
Yeah, just the one. I was told that I would have to serve 1 year in treatment.
Well, no, that's not correct. You have to serve, you have to be in treatment as long as it takes. And I'll tell you this, just getting out of treatment doesn't mean that you're going to be sober, because recovery and sobriety isn't a destination where you reach your goal and you're done. It's a lifetime journey, and you'll have to deal with it every day of your life. But under the law, it's 2 years. Well, under the law, I could do 5 years. I give a sentence of 2 years, or a period of 2 years. If you are successful and complete all the programming requirements within a year or after a year, then the court may terminate you early, but you'll still be under supervision until that time, unless and quite honestly, it seldom happens that people get out after a year, because it takes longer than a year to get your life turned around. So, you know, you can expect to be there 2 years. It could be that you would not necessarily in treatment. The treatment will be whatever your treatment team says. And so they'll keep you in as long as they think you're necessary. Then they will come up with a plan for you to transition out. They may recommend you go into transitional housing. If that's the case, you should do that. And then maybe sober living before you get out on your own, because you just can't get out of treatment after 90 days, go back where you came from and pick up your life and live it sober, because you'll fall right down on your face if you do that. I can just tell you that right now. If you go back to the same places, people, and things, I'm going to see you again, and then you're going to have a record. So does that answer your question?
Yes, sir.
All right. Anything else?
No, I think that's about it.
All right. Then is it your decision to withdraw your not guilty plea and plead guilty to the charge pursuant to the terms of this agreement that we've just gone over?
Yes, sir.
All right. Then as to the charge, which alleges that on or about October 21, 2022 in Highland County, Ohio, you did knowingly obtain, possess, or use Schedule 2 controlled substance to a fentanyl-related compound in an amount equal to or exceeding 1 gram to less than 5 grams in violation of Section 2925.11 of the Ohio Revised Code. Charge of aggravated possession of a fentanyl-related compound, a 4th-degree felony, carrying a possible prison term between 6 and 18 months and a fine of $5,000, and a possible license suspension of 6 months to 5 years. How do you plead?
Guilty.
All right. Court finds that on this day in open court, the defendant was advised of all his constitutional rights and made a knowing and voluntary waiver pursuant to Criminal 11. The plea is accepted and ordered filed. Court finds that the defendant's drug usage was a factor that led to the criminal conduct which he has admitted, and that there's a substantial likelihood that his any future criminal activity will be reduced if he successfully completes treatment. He has been accepted into and is in an appropriate certified treatment program at this time. He's otherwise eligible for community control. He's not a repeat or dangerous offender. He is eligible under the law for intervention in lieu of conviction. Therefore, the plea is accepted, but the court will make no finding of guilt at this time. Instead, the proceedings will be stayed pending a report from the probation department and the prosecutor on the defendant's progress. The defendant will be under a period of 2 years of supervision by the probation department on the terms of this program set by the court, adopted by the court. He's required to successfully complete his intervention treatment plan, including the requirement he must be alcohol and drug free for a period of at least 1 year. And if he's also ordered to pay the court costs. If the defendant successfully completes his intervention plan and obeys all other conditions of the community control, then at that time the court will dismiss the case, even though he's entered a plea of guilty, will make no finding of guilt, and instead will set the matter for a sealing hearing. If the defendant should fail to complete the program or comply with any of the terms and conditions imposed in the intervention plan or in the supervision conditions, then upon notice in writing from the probation department, the court, a copy of which will be served on the defendant, the court shall have a hearing, determine if he has failed to comply, and if that occurs, at that time the court could find the defendant guilty and sentence him for a period of between 6 and 18 months, and fine him $5,000 and suspend license for 6 months to 5 years. All right, is there anything further from council?
No, Your Honor.
No, Your Honor.
All right, probation department will be in touch with you, Mr. Barger. Make sure when you do complete residential treatment, you contact them and continue to contact them and comply with these conditions. It does complete the case for now, and the pretrial supervision conditions and house arrest no longer apply. It'll be the new conditions that they'll go over with you when they talk with you. All right, thank you.